Sometimes the biggest changes don't come from some huge, flashy new law. Sometimes it's about fixing a tiny, broken piece of paperwork that's causing a massive headache for everyone. And in Karnataka, that's exactly what happened. We're going to dive into how a simple procedural fix is untangling a very real legal nightmare.
So just imagine this for a second. You spend years, maybe even decades, fighting for your own property in court. You pour your time, your money, your energy into it, and finally, you win. You get the court decree. It's over. But then you go to get the official land records updated, and you're just told no. It sounds crazy, right? But this wasn't a hypothetical. For a lot of people in Bengaluru, this was their frustrating, maddening reality. So yeah, let's talk about that feeling. What is it actually like to win your case, to have the court on your side, but you're still completely tracked by bureaucracy? Let's look at a real-life example to see what this means. Take the case of a man named Anthony Sammy K. A special court officially canceled some documents related to his property. He had the judgment right there in his hand, clear legal proof that he was in the right. But when he went to the Sub-Registrar, they refused to update the records. Their reason? They said they never got a direct notice from the court. So even with his win, officially, nothing had changed. And here's the thing. Mr. Sammy's story wasn't a one-off. Not at all. He was just one of many people caught in this systemic flaw, this frustrating and frankly absurd endless litigation loop. I mean, look at this cycle. It's just nuts. First, you win your case. Awesome. Step 2, you take your legally won decree to the Sub-Registrar's office. But then, they refuse to do anything because they claim they need to hear from the court directly. So, what's your only option? You have to go back to court and file a whole new case just to get them to enforce a decision that's already been made. And this wasn't just a headache for regular citizens. The High Court itself used some pretty strong language to describe the situation. They called it avoidable litigation and an unwarranted burden. It was clogging up the entire system, forcing judges to waste their time on what are basically administrative issues instead of focusing on actual substantive legal disputes. Okay, so enough about the problem. Thankfully, the Karnataka High Court saw how ridiculous this was and stepped in. They came up with a solution that was remarkably clear, direct, and simple, a time-bound fix. So what was this big fix? Well, it came in the form of some new guidelines. The High Court basically created a new mandatory process, a process that forces both the courts and the sub-registrars to communicate and ensures that once a decision is made, the paperwork actually reflects it, and it has to be done fast. And the real heart of this whole fix comes down to one simple number: 4, as in 4 weeks. And that's not a suggestion, it's a hard deadline. It's specifically designed to break that old cycle of endless delays. So here's the breakdown of how it works now. That communication gap, it's gone. Civil and commercial courts now have a new responsibility. They must send the decree directly to the sub-registrar, and they have to do it within 4 weeks. Then the sub-registrars have their own deadline. Once they get that communication, they have 4 weeks to update the records. Simple, direct, and no more excuses. And they made sure there's no wiggle room here. The communication from the court has to be super specific. It's got to include everything: the document number, the date of registration, the book and volume where it's filed, and exactly what kind of document was canceled. This gives the sub-registrar everything they need to act immediately without any confusion or delay. But here's a really great part, probably my favorite part of this whole thing. What if the court is slow or just forgets to send the paperwork? Well, the new rules actually empower you, the citizen. If you show up with a certified copy of the decree yourself, the sub-registrar can't turn you away anymore. They just have to verify that it's authentic, and then they have to update the records. This puts the power back where it belongs, in the hands of the person who actually won the case. All right, so this is obviously fantastic for individual property owners, but the impact here is so much bigger than that. This is really about fixing a major bottleneck in the entire judicial process. It's about unclogging the whole justice system. And this quote from Justice Sachin Shankar Magadum really just hits the nail on the head. He says the sub-registrar's role is ministerial. Now, what does that mean? It basically means their job is to execute and record. It is not their job to question, to second-guess, or to adjudicate a court's decision. They're administrators, not another layer of judges. Their job is to stamp the paper, not to have an opinion on what it says. So the ultimate goal here is all about efficiency. The High Court wants to stop these completely unnecessary cases, these avoidable writ petitions, from ever being filed in the first place. By fixing the process right at the source, they stop the problem from ever escalating to a higher court. And the benefit of that is just enormous. It frees up our judges. It preserves what the court itself calls scarce judicial time. So instead of dealing with what are essentially paperwork follow-ups,
Judges can finally focus their full attention on the complex, substantive cases that actually require their legal expertise.
Okay, so we've looked at the problem, we've seen the elegant fix, and we understand the reasoning behind it. But let's bring it all back home. What does all of this really mean for you?
Let's just boil it down to the key takeaways. What we have now is crystal clear communication between courts and registrars. That means you get faster, more reliable updates to your property records. For citizens, this is huge. It means a dramatic drop in the need to file lawsuit after lawsuit for the exact same issue. And for the system as a whole, it means a much more efficient, less burdened court system that can actually do its job.
And that kind of leaves us with this one final thought, right? We often think justice is about some grand verdict in a courtroom or a big, sweeping new law. But what if the most profound form of justice is simpler? What if it's just about fixing a broken process so that it actually works for people? This case really shows that a victory in court should be the end of the fight, not just the beginning of another one.